the Director of the National Center for Interstate Compacts at the Council of State Governments, and on behalf of our staff and especially our members scattered around the country, let me thank everyone for taking about an hour of your day to join us. This is the first in a planned series of webinars about interstate compacts. Today we'll learn a little something about the background, history, and modern use of compacts from Rick Masters, who serves as special counsel to us here at the National Center for Interstate Compacts. And so in just a minute, I will turn the floor over to Rick with just a couple of housekeeping items before we do get started, before we do turn the floor over to Rick. Everybody should be on your screen right now, should be seeing an introductory slide, Interstate Compacts Background, History, and Use. As Rick continues to click through the slides, you'll be able to follow along with him on the screen. If for some reason you missed something, we will also post this. It will be posted in CSG's Knowledge Center probably early next week. It will have the full broadcast along with the accompanied slides. And you will also have my contact information at the end of the presentation should you have any follow-up questions or that sort of thing. Regarding questions, we will have an opportunity at the end of the broadcast to take some Q&A from Rick. All you will need to do is in the chat box in your GoToWebinar screen, type the questions out because everybody will be muted simply to avoid feedback. Those questions will come through to us, and I will be able to ask them directly of Rick. Like I said, we'll take about an hour. I suspect it'll take Rick probably in the neighborhood of 30 minutes or so, 35 minutes to run through the slides. And my goal is to have plenty of time at the end of the broadcast for Q&A and that sort of thing. So with that, I want to go ahead and get started. Let me give you all Rick's background and bio, and then I will turn the floor over to Mr. Masters. Rick Masters is the Special Counsel for Interstate Compacts and legal consultant to the National Center for Interstate Compacts operated by the Council of State Governments. He also provides legal advice and counsel to 3 interstate national compact commissions, which are affiliated with CSG. He received a BA degree from Asbury College and a Juris Doctorate from the Louis Brandeis School of Law at the University of Louisville. He was formerly Assistant Attorney General for the Commonwealth of Kentucky until 1982 and has served as General Counsel for CSG at our national headquarters in Lexington, Kentucky in a previous life. Rick has written and spoken extensively on the subject of interstate compacts and is the principal draftsman of the Interstate Compact for Adult Offender Supervision, which has been enacted by all 50 states, the Interstate Compact for Juveniles, which has been enacted now by 49 states, and the Interstate Compact on Educational Opportunities for Military Children, which has been enacted by 46 states. In conjunction with CSG, he has also consulted with the National Highway Traffic Safety Administration, the United States Department of Justice, the U.S. Department of Defense, and the U.S. Department of Homeland Security concerning various interstate compact projects, including some of those I already mentioned and some of the ones Rick will probably talk about here a little bit later in his remarks. Rick continues to be involved in consultation, research, and writing concerning interstate compacts and constitutional law issues, and is one of the primary authors of The Evolving Use and Changing Role of Interstate Compacts, a Practitioner's Guide, which was published by the American Bar Association in 2007, and is in the process, I believe, of being updated currently. On top of all that, Rick is joining us remotely from the state capitol in Minnesota, where he's been giving testimony on the Interstate Compact on Educational Opportunities for Military Children. So the timing of this presentation is absolutely perfect, and with that, I will gladly yield the floor to Rick Masters.
Well, thanks, Grady. And when we planned this, we weren't sure where we would be, whether in an office or somewhere else. But it turns out the venue is the great state of Minnesota, and I am grateful to the Office of Governor Dayton for allowing me to have a space in which to temporarily reside as we talk a bit about interstate compacts, and happy to have the opportunity to do it. I was reminded, however, to keep my geography in check, and that the capital of Minnesota is actually in St. Paul, Minnesota, not Minneapolis. So those of you who may suffer from a lack of geographic specificity something to keep in mind, especially when you're in Minnesota. So with that said, let's talk for a bit about interstate compacts. As Grady said, I am in fact up here today just to illustrate the continued durability and usefulness of interstate agreements, to testify, and have just completed testimony before the Minnesota Senate Education Committee and the House Education Policy Committee concerning the Interstate Compact for Educational Opportunity for Military Children, which is one of many compact projects in which CSG has been involved over the years. And this particular one, our partners have been the Department of Defense. But again, it's kind of a not intended to be a dramatic illustration of the fact that these instruments continue to be used in all sorts of areas of government endeavor, and we'll talk more about that as we go through these slides. Let's go to our next slide, Carrie, and talk about the nature of compacts, and then we want to give plenty of time for questions. Probably the most important point to remember is that compacts are a proven tool which have been documented in terms of success over time, as well as having developed over a sufficient number of years that there is quite a body of case law as well as statutory law that supports the existence and the application and interpretation of compacts. To put it concisely, a compact is in actuality a contractual relationship between the states that enact the legislation creating the compact. And like private parties to a contractual agreement, the states that are parties to a compact have the same source of constitutional and contractual obligations that private parties would have. And so if you keep in mind the concept that a compact is a contract, I think analyzing these instruments and understanding them is much easier, because I think we all have frames of reference with private contracts in which we've been involved, both as consumers and perhaps in business and in other areas of endeavor. However, for governmental purposes, the purpose of states entering into these sorts of contracts is to address problems that transcend the ability of one legislature to deal with. And the problems that we're talking about in that regard are those in which crossing a state line is involved. When you think about it, a state legislature regulate transactions that occur within state borders. Once a state line is crossed, the ability of the state legislature to regulate that problem doesn't exist in the absence of some statutory framework in which the states have mutually agreed to address that problem through collective exercise of their power. And on many occasions, the vehicle of choice to accomplish that is an interstate compact. It allows the states to continue to manage problems and to use state-based solutions and avoids the problem of states having to be preempted in their ability to regulate by the federal government. So I think the last line of this slide kind of sums it up best as we talk about compacts, in that they allow states to retain collective sovereignty over issues belonging to the states, and yet achieve the uniformity that sometimes folks think can only be achieved through federal action, and that's really not the case. A compact is an alternative, and in many cases, state governments feel a better choice. Let's go to the next slide. The concept of a compact, obviously, is a proven tool because of the history and the extensive period of time over which compacts have been used. In fact, interstate compacts in the United States go back to the period of colonial relationships between the 13 original colonies, even before there was a country known as the United States of America or a constitution. And the earliest compacts were used to resolve boundary disputes between the colonies. So as you can see, when we say interstate compacts are not new, they are as old as our country is, in fact older. But what's changed is the use of interstate compacts to achieve a wide variety of ongoing administrative regulatory purposes. Next. Compacts are recognized under our federal Constitution. Our founding fathers wisely and presciently put into the Constitution what is known as the Compact Clause in Article 1, Section 10, Clause 3, that's being displayed on the slide that you see right now, which indicates, actually it sounds more like a prohibition, that no state shall, without the consent of Congress, enter into any agreement or compact with another state. That sounds as if, to ordinary students of English grammar, that all compacts require congressional consent. But as I have said in the past, the U.S. Supreme Court has determined that in this case, the word any doesn't mean all. In other words, enter into any agreement or compact doesn't mean that all compacts are subject to this consent requirement, and that the consent of the Congress of the United States is only required for a compact which may impinge or infringe upon some enumerated power that is set out in the U.S. Constitution. But what this implicitly does, and by that I mean the Compact Clause, is recognize the right and the authority of the states to enter into agreements, and even agreements which have not been consented to by the Congress of the United States, and Congress only has to be consulted when some enumerated federal constitutional power has been called into question. And there's a case there on that slide that demonstrates that issue and analyzes it for you lawyers in the audience, and there are many other cases besides that one, but that's one of the more effective and efficient ways of the Supreme Court's analysis being understood and read, if you care to do so. Let's look at the next slide. In summary, compacts are currently used for three primary purposes. First, they are still, to this day, used to resolve boundary disputes, not between colonies, but between the states of the United States. And frequently, those boundaries change. When I was in the Attorney General's office in Kentucky, we had a dispute with the state of Ohio over where the boundary between Kentucky and Ohio existed as concerns the Ohio River. And as any of you know who study the scientific aspects of erosion and other characteristics of bodies of water, a river over time moves. And so the boundary that was established in the past had to be adjusted and continues to be adjusted through the use of an interstate compact. A second use of these interstate devices is to manage other sorts of natural resources. As I have frequently said, show me a river basin and I'll show you an interstate compact, because in most, if not all cases, river basins extend across a number of states, and all of the river basins that I'm aware of use interstate compacts to manage those natural resources, whether it's for fishing rights, water rights, pollution, and other water aspects of management and regulation of bodies of natural resources. Finally, and more to the point that we're making today, among all the others, is that compacts are being increasingly used to create interstate administrative agencies which regulate a wide variety of state activities. And again, the criteria for possibly using a compact to solve such a problem is, does the matter involve traditionally state exercised authority, but does it also involve a transaction or series of transactions that occur across a state line and transcend the borders of any one state? Let's move to the next slide. Some statistics for you. On average, every state is a member of at least 24 compacts. Some more, some less, but approximately 215 compacts have been adopted by the state legislatures, either by state, regional, or national, since the ratification of the Constitution. So as you can see, these mechanisms are not newly discovered means of governmental regulation and are used, as I say, on average of 24 times by each state in a wide variety of state regulatory activities. One of the earliest compacts establishing an interstate administrative authority was the Port Authority of New York and New Jersey, which many of you will recognize as the entity that regulates airplanes, ferry boats, trains, buses, and any type of public conveyances between the states of New York and New Jersey, and transportation-related entities, properties, including what were formerly known as the World Trade Centers, which were under the jurisdiction of and the control of the Port Authority of New York. It has a multi-billion-dollar budget in today's world and does a vast amount of work regulating transportation in those two member states, and even has its own police force. Let's look at the next slide. You may have trouble seeing it, although on my slide, if you can squint, you can see the numbers. This is a state-by-state breakdown on the map of the United States showing the number of compacts that we have researched and recorded are enacted by each state individually. You may want to save this slide or get a copy of the presentation so you can look at the number in your own particular state. There may be one or two here and there that have been added or deleted since this slide was prepared, but I think you'll find that that's a pretty accurate pictorial representation of the number of compacts that each state currently has enacted. Let's look at the next slide. There are other forms of multi-state cooperation, and we certainly would be remiss if we were not to point out that an interstate compact is not the only way that a state can enter into some type of relationship with another state to manage a particular problem. And we've got some examples of other types of activities that are not interstate compacts by which states do this. However, I think you'll find that in most cases these are much more narrow in scope and regulate particular aspects of one issue, such as the tobacco settlement litigation that was presided over by the National Association of Attorneys General and entered into an interstate or multi-state settlement agreement that set up a fund by which these states would be compensated for health care costs and other problems that were created by smoking and was paid for by the tobacco industry, which represented the defendants. But again, it's focused very narrowly on the settlement of a legal dispute rather than the management of some much bigger governmental problem. Another way that states use to regulate problems on an interstate basis is through what are called uniform state laws. There is an organization which used to be known as the National Conference of Commissioners of Uniform State Laws, but the acronym was so long that they threw it out and have changed it to the Uniform Law Commission. And this is a group of parties, lawyers, legislative drafters, folks involved in various areas of state regulation that have created various types of uniform statutes that legislatures adopt that are similar in most cases, but unfortunately, I think even those that deal with uniform laws on a regular basis would tell you that the primary characteristics of a uniform law is that they're really not uniform and that states are free to change them, and that while it is preferred that states that adopt uniform laws adopt the same statutes, there is no requirement that that be done, and states are free to enter into variations that sometimes can be widely at variance with each other. Some examples of uniform laws that are used for these purposes are the Uniform Commercial Code, for example. There are uniform child support acts that have been adopted by the states, and jurisdictional statutes that are uniform to regulate such issues as enforcement of child support obligations. Again, They differ from compacts. They are another way, another alternative that states can use to regulate, but do not contain a requirement that all states must adopt complete uniformity, nor do they have any kind of enforcement mechanism that is set up within the compact or within the law itself to implement or hold states accountable for the variance or the failure to comply with the uniformity. And then finally, there are a much more narrow set of agreements that truly are for the purpose of specific contractual objectives that have been desired to be achieved by agencies that may enter into agreements with each other. And by that, I'm talking about perhaps purchasing agreements where a state might purchase facilities or equipment or other commodities from another state and enter into a contract between state agencies to do that. And these can be even less formal than a legal contract. And so, again, I think you'll see that while these are other ways of addressing interstate problems, they're much more narrowly focused to a specific transaction. Let's look at the next slide. To summarize the primary benefits that states can achieve through the use of compacts, first of all, is creating economies of scale. If there are transactions that are recurring on a regular basis, states are going to have to find a way to deal with them, whether or not they've entered into an interstate agreement to do so. And when you think about it, it is just a matter of efficiency to try to combine necessary activities that state governments have to enter into and accomplish anyway into a uniform system of management rather than have to deal with these problems on an ad hoc basis. Compacts also provide a degree of flexibility and autonomy that federal regulation does not. Compacts can be entered into on a national basis on some issues where all 50 states are members, but frequently that's not required. And regional approaches to problem solving can be adapted through the mechanism of an interstate compact. A good example is what we've already mentioned of natural resources management, such as river basins and other natural wonders, where they, by definition, only involve states in a certain region or where a certain geographical area is involved. Compacts can provide for a method of states to resolve disputes, and that can include such things as mediation and arbitration, which, as most private parties and businesses would acknowledge, is usually a less expensive and a less time-consuming way to resolve disputes. And compacts increasingly are using alternative dispute resolution mechanisms as well. Compacts also provide for the states and the federal government to work together in appropriate cases. And as I said when we began our discussion today, I'm in Minnesota as the result of a partnership that was entered into between the Department of Defense and Council of State Governments, and now we have 46 states that have chosen to manage a particular problem involving U.S. military personnel who have to uproot their families and move from one state to another to enroll their children in grades K through 12 in states that sometimes have conflicting requirements concerning educational processes. And so that's a good example of that value that's served by compacts. Finally, I think you could sum it all up as saying it gives states an opportunity to achieve a win-win solution to a problem where economies of scale are achieved, states maintain their own collective sovereignty that can be exercised together, and the federal government is not needed to manage the problem or to preempt the states. Let's look at the next slide. There are many activities that are regulated by compacts, as we've already mentioned and seen so far in the presentation. The manner in which these problems can be operated and managed is used, are exemplified by a number of compacts that have such things as a national data or information sharing system. One example that comes to mind is the Interstate Compact for Adult Offender Supervision, where all 50 states have adopted that compact, and through the auspices of that compact, information about offenders on parole or probation who want to relocate across a state line is made instantaneously available by a computerized data system that allows that information to be electronically transmitted. That is a marked difference with the compact before the revised Interstate Offender Agreement was entered into as CSG and other organizations worked together to do that. And before the new agreement, now known as Interstate Compact for Adult Offender Supervision, was adopted by all 50 states, information was collected on a snail mail basis and communicated by regular U.S. mail channels, and in some cases didn't arrive until weeks or months after an offender had already crossed the state line, resulting in gross inefficiencies and in some cases risks to public safety. Compacts also allow for uniform rulemaking in the particular area that states desire to regulate. It provides a governing structure where all states have equal representation at the table, and I mentioned one of those types of compacts already. Actually, I've mentioned two of them, the Interstate Compact for Educational Opportunity for Military Children, as well as the Adult Offender Compact, are but two examples of compacts that have created national commissions that consist of representatives of each state to provide a governing body to hold states accountable to their agreement and also to develop new ways of managing the problems that each compact is charged with carrying on. Compacts give an opportunity for external stakeholders to gather in appropriate cases with the regulatory bodies that manage these compacts, and external stakeholders that have a stake in a compact and the aspects of regulation that it engages in can be brought together and can be part of the conversation. Compacts allow coordination with each other, and increasingly we're seeing compacts such as the Interstate Compact for Juveniles and the Interstate Compact for the Placement of Children that involve, in some cases, overlapping placements of youth, trying to work together, and even including language in the newly revised Interstate Compact for Juveniles, specifically recognizing that ICPC and ICJ will work together to manage these sorts of problems. Compacts also provide the ability of states to create a national office to manage these problems and assist the states in carrying out their responsibilities. Let's look at the next slide. Rulemaking is something that regularly causes concern, I think, among individuals that are regulated as well as legislators. But regulation is necessary in part because a compact, like all statutes, has to be amended by action of the legislatures. And when you have a compact, particularly one in which all 50 states are involved, the task of having all 50 states revise the compact statute is Herculean, to say the least. And so one of the reasons why rulemaking is used both on an interstate basis and an intrastate basis is so that it is not necessary to continually have to go back to the legislature to tweak it here and there to carry out objectives that are generally granted under the statute but may not be specifically reflected in the statutory language, or else we'd have so many pages of text that no reasonable person could read it. Some would argue we're at that point now. But one of the ways to solve that problem is to delegate regulatory authority to an administrative agency, and compacts as interstate administrative agencies can be given authority by their member states to engage in regulation if there's a proper delegation of authority, which is expected in any such activity. And here's a case in this slide that recognizes that authority as long ago as 1950s. Next slide, please. Here are several compacts that embody some of the characteristics that we've already discussed, and I've mentioned at least 3 of them already, and I'll just direct your attention to that list. CSG has a comprehensive list of all of the compacts that are in existence today, and you can obtain those from the National Center if you want more information about them. Next slide. We are involved in ongoing work concerning the development and implementation of compacts in which we participated. And as you can see, there is a wide array of activities in which states are attempting to use compacts to manage problems. For example, transmission line siting, a very controversial area, and that's being studied now. I think it's in what I would call a germinal stage and has not resulted yet in a wide adoption of an electrical transmission compact, but certainly the text of such an instrument has been discussed and is being vetted for possible use in helping to solve that kind of problem. We're recently challenged with questions concerning healthcare licensure, and you'll see the last 4 bullet points on the slide that's on the screen now are examples of the increasing awareness of regulatory bodies at the state level that licensed health professionals, whether they be doctors or EMS professionals or nurses or physical therapists or psychologists, increasingly are being called upon to engage in modern means of medicine, which is practiced through the use of electronic devices, and usually where the patient is located in a different state than the doctor. And when that occurs, licensure in both jurisdictions is generally required. But the burdensome nature of the licensure process is such that in the absence of a centrally managed way of obtaining multiple licensure recognition, you have to laboriously and expensively obtain a license to practice any medical profession, with the exception of nursing, by applying to each state individually. The nursing profession has adopted a nurse licensure compact that does recognize the privilege to practice nursing in any of the 24 states that have enacted that compact, but that has not been the case with other medical professions and professionals such as those featured in these items on this slide. And CSG is currently working with each of those groups to vet multi-state compacts that would recognize multi-state practice and facilitate the electronic use of medical interventions, sometimes called telemedicine. This also helps solve some of the problems that have been created by the advent of the Affordable Care Act, where we have hundreds of thousands of new patients that have never been in the system before that are now insured under ACA. And those folks all need doctors and physical therapists and EMS personnel and psychologists and other medical professionals to care for them. We think compacts, and the associations representing these groups think that compacts is a viable way of solving those problems. So more on that later. Next slide. Here are some technical assistance summaries of how it typically comes to be that a compact is developed and produced for adoption by legislators. We have phases that are typically used by all of these groups that sit around the table to negotiate a compact. And while I don't want to suggest to you that this is a recipe that must be followed in every case, I think it's a pretty generic means of accomplishing the goal of bringing all the necessary stakeholders together to make sure all of the people who have an interest in the regulation of a particular problem are at the table, certainly including both state officials and those who are regulated, to design solutions if an interstate compact is targeted as one of the tools to be used that center around the current policy issues, the current practice issues, the current professional needs of each area that is being analyzed for use in possibly being regulated by compact. And the drafting phase, as we've got featured here in the second section of this slide typically is an 8 to 12 month period, and then after that, you certainly must allow sufficient time to give legislators and policymakers the opportunity to become aware of the compact and to vet it for purposes of possible legislation. We've got there a time frame that may or may not be true in all cases, but it's sort of our best estimate of how long this would typically take in a compact that has defined objectives and a good plan like the one you see here. Next slide, please. We have web addresses and phone numbers where you can reach both of us, and I urge you to route any questions you have after this session, because I'm sure there may be some questions or comments or information that you may want to request from either Crady or from me, and we ask you to go ahead and submit those after this webinar is concluded through the Council of State Governments. My suggestion is route them to Crady, although if you want to follow up with me, I'll be happy to take any calls that you may have if you want to try to get in touch with me. And I appreciate the opportunity to talk with you today, and hope that we can provide some information that's useful.
Thank you, Rick. I appreciate your taking the time to join us, especially given your travel schedule and whatnot. If you don't mind, we do have a couple questions that have already come in, have been submitted electronically. I'll go ahead and run through those if you're willing to take a couple questions. I will also make a note to the audience. If you have additional questions, you can submit those, as I said earlier, in the text box on your GoToWebinar screen. Those will come directly into our staff, and I'll be able to relay them to Rick. So with that, Rick, first question reads as follows. Mr. Masters, you spent a few minutes talking about congressional consent. Could you go into a little more detail, specifically talking about both the advantages and disadvantages of seeking consent on a given compact?
Yeah, in fact, I've written a book on that subject, or at least it contains a chapter on it, so I won't answer it to that extent, but that's a question that frequently arises, and it can be both a blessing and a curse. First of all, it's important to understand what difference it makes if congressional consent is required and is granted. And the difference is that once congressional consent has been granted, the compact, according to the Supreme Court of the United States, acquires the status and the weight of federal law. And so in addition to being a contractual obligation that is protected under the contract clause of the Constitution, under the compact clause, the compact that receives congressional consent actually would supersede any conflicting state law or regulation under the supremacy clause of the Constitution, which says that federal law shall predominate. So that can be helpful when it comes to transactions that it is required have that level of legal force, and in some cases it can't be avoided. For instance, the Adult Offender Compact has congressional consent, and the reason is because it is an alternative to extradition of fugitives from justice in some cases, and that, for you lawyers in the audience, you may recall, is a portion of the federal Constitution known as the Extradition Clause. And so that compact, by its nature, is going to impinge or potentially infringe upon the enumerated authority under the Extradition Clause. So compact, for the Adult Offender Compact, required congressional consent, and you didn't have a choice, and typically that's the case. Compacts that do not have congressional consent don't have the weight of federal law, but they are protected by the contract clause of the Constitution, which says that that no state shall impair the obligation of contracts, and that includes contracts between states. And impairment has been defined as enacting a statute that would conflict with the provisions of the compact. So while they are protected, it's under the contract clause unless congressional consent is required, and at that point, the compact and any rules that it promulgates becomes the equivalent of federal law.
Thank you, Rick. Next question. You referenced the budget of the Port Authority of New York and New Jersey. Could you talk a little bit more broadly about how compacts are funded, and especially how compact commissions are funded?
Yes, that obviously is again a question that legislators are frequently interested in, and there are a variety of means by which a compact can be funded. It could be funded by direct appropriations from the legislatures of the member states. It could be funded on a fee-for-service basis, such as a licensure compact, for example, where you pay a fee to the state for obtaining your license to do something, and that fee is used to defray the cost of operating the compact. Other means can be developed depending and limited only by the imagination and creativity of the drafters of the compact. However, it is important, in my view, that whatever funding mechanism is chosen, that the state or states that make up the compact should be what I call the funder of last resort, because there's some Supreme Court decisions out there that suggest that if you want to claim as a state official that you have continued to maintain your sovereign immunity that would normally protect state officials in the reasonable exercise of their discretion from liability for lawsuits, for injuries and other things, you might jeopardize that if you have created a private funding mechanism for the compact, which does not depend in any way, shape, or form on the governments that make up the interstate compact. It's a subject that we could spend a lot more time on, but maybe that's a start at trying to understand how and the wide variety of ways compacts can be funded.
Thank you, Rick. Another question from the audience, and just a heads up, if you do have questions, you're welcome to use that text box. Another question from the audience, Rick, could you talk broadly about some of the trends you're seeing in interstate compacts and why you think states, and even more specifically some of the organizations that you alluded to in your remarks, are turning toward compacts with increasing regularity?
I think one of the best examples of that trend, or one trend in the use of compacts, is for purposes of health professional licensure. And I think compacts are being considered in large measure because, particularly with regard to professional regulation, this has usually, in fact, I would go more, at the risk of being overly broad, I would say state regulation is typically and traditionally responsible for the regulation of professional licenses. And there are those who believe that because it could be more cumbersome to have to solve this problem through either an interstate compact or some state-based solution, that perhaps the federal government would be best suited to manage these kinds of problems and solve them instead of the states. But my belief is that those who are responsible for regulation in many cases, and probably most of the people that are regulated, would prefer not to have a federal entity regulating them if there is a viable state solution. So I think that's a primary reason why health professionals, for example, are looking at these kinds of approaches to solve these kinds of problems.
Thank you, Rick. That is it for questions for now. Like I said, we will have this webinar posted. It will go into our Knowledge Center at CSG here probably the very early part of next week. You will actually get an email generated from GoToWebinar, the same email address that generated the web link and the phone number, providing that link. So all the slides and Rick's comments will be available, as well as the Q&A portion of the webinar today. The other thing I will add is that if you think of additional questions, if you'd like some more information, you could certainly visit CSG's website and specifically search for the National Center for Interstate Compacts. That link is www.csg/NCIC. We have a host of resources there. Maintain a database with each compact that a given state has joined. It's a wonderful resource. I certainly encourage you to take a look at it. You're also more than welcome to forward questions directly to me or to give me a call. My contact information, Crady Degolian, was on Rick's last slide. You have my email address and my direct dial here at the office. And so certainly if you have any questions that you'd like some additional clarification on, or you think of something here in the next couple days as you sort of mull over Rick's comments, you're more than welcome to reach directly out to me. With that, I would once again like to extend a sincere thanks to everyone for taking an hour or so to join us today to learn a little bit about some of our ongoing work in the world that Rick and I live in, and certainly want to take a sincere thanks to Rick for not only taking the time to be here, but sharing his wealth of expertise with this group. Rick has always been a tremendous resource to CSG, and certainly we thank him for all of his hard work and dedication on behalf of our members. So, Rick, with that, thank you, and we are adjourned.
Thanks, everyone.